Was Blake Lively's subpoena real? How do you subpoena for a CRD complaint before there's actual litigation? And also, did she really win in court this week? I have two attorneys on. They're going to help break it all down because, listen, I may be Al Woods, but I haven't gotten my Harvard Law degree yet, and they're a lot smarter than I am. So get ready. Let's dive in. You're listening to No Filter with Zack Peter, your go-to source for all the latest pop culture and reality TV tea, served fresh all week long. Now, let's dive in. And dive in we shall. They're two of your favorites. They're gaining lots of popularity on YouTube already. Please welcome back on the podcast, Stewart Albertson and Keith Davidson. Hey, guys.
Hey, Zach. How you doing?
I'm great. How are you?
I'm doing good. Full disclosure, I haven't gotten my law degree from Harvard yet either.
Well, you're a few steps ahead of me.
I do have a law degree. Yeah, just not from Harvard.
How has this case been going? Your YouTube has been growing and growing.
Yeah, it's been really great. And we've enjoyed just going through the documents and, learning about the case along with everybody else and showing everybody kind of what we have to offer, I guess, in terms of our analysis of the legal side.
Yes, guys, lots of great videos. I've been on the channel. Dave Neal, we love Dave Neal. Dave Neal and I, he's going to be in LA. So we're going to be doing another collab together, but definitely support Albertson and Davidson, AD Law on YouTube. Go give them some love. All right, guys, we have lots to get into. What was your reaction? Well, first of all, it took forever for the judge to make a decision on this protective order. I thought it was easy and we were going to have something by Monday. Were you expecting him to take this long for him to rule on Blake's protective order?
I'm not surprised he took a week. I mean, it's a thorny issue, and the judge had to strike a balance. And I think the overall objective for the judge is, how do I keep these parties out of my courtroom over endless fights? And it wasn't an easy thing to figure out. So taking a week didn't surprise me. I mean, sometimes judges will take longer than that. But I thought that he constructed something that at least was workable. And, my hat's off to the judge for coming up with that order.
Yeah, and so just to recap it, so he granted her attorney's eyes only protective order, but he limited it to trade secrets, so confidential business plans, which was the argument that Leslie Sloan was trying to make, that, she's a publicist, she has a PR firm, Jennifer Abel, also publicist, PR firm. They wanted to make sure that there were no trade secrets that came out. So unless it's specifically related to It Ends With Us, it will be protected under the attorney's eyes only. We also have security measures and medical information, which were the two things that Blake Lively's attorneys brought up in court. They said, hey, we want to protect her medical info and her security. And Brian Friedman was basically like, well, we don't care about any of that. We don't have any plans on leaking any of that or exploiting that in any way. We just want to get to the truth. But then the real kicker, and I think this is where she probably did have somewhat of a win, and that's the highly personal and intimate information about third parties. And so this is where people are really honing in on it being related to Taylor Swift and some of the other high-profile celebrities attached to this. We have Hugh Jackman. We also have Bradley Cooper. Arguably, Jenny Slate may be considered one of those high-profile third parties. So my understanding, and please correct me if I'm wrong, is that Brian Friedman will be able to access their information should there need to be. He would probably need to issue a subpoena and then access that info. And depending on what gets drawn up in the information, such as text messages, emails, whatever, if it directly relates to It Ends With Us, then he's allowed to share that beyond the attorney's eyes only, and anything outside of that, he's not allowed to discuss with anybody else, correct?
Yeah, pretty much. And so I think there's two prongs that the attorneys are going to have to struggle with. One is this personal and intimate information? Right. And if it's not, then it's not attorney's eyes only. And then secondly, is it directly relevant to the claims and defenses in the case? And if it is, it's not attorney's eyes only. And so at least it puts a burden on the attorney who's making the designation. It applies equally to both sides. Right. And they have to at least jump through those hoops before they mark something attorney's eyes only. Now, if they do that and the other side says, hey, I think you were wrong, I don't think this meets the elements, then they can go to the judge and they can figure it out. So it's not the be all and end all. There still probably is going to be arguments and fights over things, but at least it gives a groundwork.
And so the press has been reporting that this is a win for Blake Lively. Page 6 says Blake Lively scores a win in Justin Baldoni legal battle as judge grants protective order. Deadline reports Justin Baldoni loses highly personal and intimate information court battle with Blake Lively. And Variety reports Blake Lively wins confidentiality order for sensitive information in Justin Baldoni lawsuit, making it seem like he wants to access her sensitive information. And the judge said, no, you're crossing a line here. Stuart, do you think this is a win for her, like the media is reporting?
I don't. And when Keith and I looked at the order yesterday, we did not go to the media first to test the air and figure out what the major news sources were saying. Keith and I went through the order and we broke it down, and nobody breaks an order down like Keith. And we looked at it, and this is a win for Justin Baldoni at the end of the day. And the reason it is the other side, Blake Lively's team, wanted to have a unilateral right to mark documents attorney's eyes only. And that was not given to them by this judge. And this fourth category is a bit problematic, but I think there's a few misunderstandings on this. Let's say that something is marked attorney's eyes only by Blake Lively's attorneys. They still have to turn that over to Brian Friedman, and Brian Friedman can look at it and go, hey, this is BS. This is not attorney's eyes only. And we take it back in front of the judge, and we have the judge determine if this is an AEO document or not. So it doesn't mean that these documents will never see the light of day. And then one other misnomer is the text messages. Well, the parties got to provide text messages back and forth to each other that are relevant to this case under federal law. They just have to voluntarily do that. And then you can also ask by way of subpoena if you need to. But Taylor Swift, that's the big question everybody's asking. Are we going to get these text messages? A subpoena can still be sent to Taylor Swift. This order has nothing to do with Taylor Swift other than she's a non-party. It does talk about non-parties. Taylor Swift and her cadre of lawyers, you will be hearing from them on whether text messages have to be given or not. So this order really doesn't get to that point.
Right. And so how I've explained it, and again, correct me if I'm wrong, is if there are text messages where Taylor Swift says, hey, yes, let's get this composer fired, or she's like, hey, Blake, did that composer get fired from the set yet? That is obviously relevant to the case. But if she's texting Taylor Swift and she's like, oh my God, Travis Kelce's D was so fired last night. He took me out here and we were dining out on this. Those are not relevant. And Brian Friedman, though he may get a kick out of those text messages, those will likely never see the light of day. So Taylor Swift is still entitled to her privacy. We're not going to find out any intimate details about her relationship with Travis Kelce or any of her tour secrets or any kiki that she has between she and Blake. Only things that are specifically related to It Ends With Us. And at this point, it kind of feels like Taylor Swift did have some sort of strong involvement beyond just lending her song.
Yeah, and I would say that's exactly correct. The way that you describe it, that is right.
The only thing I would add to that, though, Zach, is those text messages between Taylor Swift and Travis, those would never even go over to the other side. They would never even be marked attorney's eyes only unless there's a court order that they have to go over. Because again, you got to remember, Taylor Swift, she's worth a little bit of money. I think she's going to have a cadre of lawyers on any subpoena that goes to her, and she's going to be showing up in court saying, no, I don't have to turn this stuff over to begin with. These are my private text messages. Now, if there was communications about, hey, we want to fire this director on It Ends With Us or whatever the case may be, that's fair game, and likely that'll have to be produced.
Right. And so now what about Hugh Jackman and Bradley Cooper? So Hugh Jackman, we know, was a big part of the promotion of It Ends With Us. He was doing bits and skits with Ryan Reynolds, which was very strange that they were doing comedic bits about a movie that's, dedicated to bringing awareness about DV. So I would assume he will likely be deposed and dragged into this as well, being that he had a very active role in the promotion of the film. And then I would imagine Bradley Cooper gets brought into it because we've heard unconfirmed rumors that he participated in an advanced screening of It Ends With Us with Blake Lively's edit of the film, and he got access to the early edit, and she also thanks him specifically in the end credits for It Ends With Us. So we don't know what his exact involvement is, but I would imagine Brian Friedman's probably going to go after those high profile names and possibly, may get Blake Lively to buckle to protect her famous friends.
Yeah, I think so. And I think, again, it comes back to, are their communications personal and intimate? And if they're talking about the movie, it's not personal and intimate. And so all of that gets to be disclosed, or at least not attorney's eyes only, goes to the parties. I think that's very important. I also think that it's interesting how you can apply pressure in any lawsuit in ways that aren't directly related to the legal aspects of it. And so if Blake Lively wants to protect her celebrity friends from them having to expose their text messages, that's a really interesting leverage point for Baldoni's side that doesn't have anything to do with necessarily the underlying legal claims.
Right. So Fair is asking, can't they just delete their text messages? And say they do delete their text messages, what would the process be of digging those back up?
So this will be different for parties and non-parties. So Zach, you can delete your text messages today all you want. I can delete my text messages all we want. That's just something we can do. Once we become a party to a lawsuit and we delete text messages that have relevance to that lawsuit, that's where the problem comes in. And you do have a duty that once a lawsuit is filed, whether you're the plaintiff or the defendant, you should not delete any emails, text messages, smoke signals, documents of any kind that have any relevance to the case, because if you do, that could be held against you. Now, Taylor Swift is not a party to this case. And so if she wants to delete her text messages all day long, she can do that. There's no, and especially if she can say, hey, that's just my practice. I get so many text messages, I can delete them. But if Brian Friedman asks Blake Lively or Ryan Reynolds or whoever else, I want these text messages between you and Hugh Jackman and you and whoever, and the parties actually have these text messages, that's where this protective order comes in. That's where the analysis starts. Do we have to turn this over? Is it an attorney's eyes only designation, or is it just, hey, I got to give this to the other side?
Right. So, I mean, we're not going to get anything salacious outside of what is relevant to this case, which I feel like at the end of the day, as much as maybe the general public may want some juicy text messages from Taylor Swift, at the end of the day, we really just want to know what role she actually had in all of this, as with, any of the other high profile friends, Jenny Slate included. She clearly has some sort of, I assume the attorney's eyes only protection is not going to protect Jenny Slate outside of medical records, security, and trade secrets, which I don't think either of those three would be relevant in this case, correct?
Yeah, that's right. And that's where I think it's a win for Baldoni, is that all of these text messages that are directly relevant to the case, they're not going to be designated attorney's eyes only.
Right. So it's not really a win for her at the end of the day, right?
No, I gave the win to Baldoni. I think Lively got a few things that she wanted, but if I was on the Lively side and listening to and looking at what their arguments were, I wouldn't feel good about this. I'd feel like we kind of lost the battle. Whereas on Baldoni's side, I'd be like, we had to give up a couple things that we don't care about, but by and large, we got what we wanted.
Yeah, and I think they issued statements to TMZ that I'll read for us, because they both continue to make it seem like they win. They won with whatever the judge decides to rule. Brian Friedman said, "We're fully in agreement with the court's decision to provide a narrow scope of protections to categories such as private medical health records and personal security measures that have never been of interest to us, as opposed to Miss Lively's exceedingly overbroad demand for documents for over a 2.5-year period of time, which the court rightfully quashed." Now, they narrowed the scope, and my understanding is she dropped it altogether, correct?
Which scope of the discovery?
2.5 years of the phone records.
Yeah. No, the court really did quash that, and she withdrew her subpoenas. Now, she could reissue the subpoenas with the court's ruling in mind and limitations in mind, but the court did cancel those subpoenas.
And then Friedman continues by saying, "We remain focused on the necessary communications that will directly contradict Miss Lively's unfounded accusations. We will oppose any efforts by Miss Lively and her team to hamper our client's ability to defend against her attack by incorrectly categorizing important information as trade secrets, especially considering there were no issues in providing these communications willingly to the New York Times." Very good point. And then Blake Lively spokesperson said, "Today, the court rejected the Wayfarer party's objections and entered the protections needed to ensure the free flow of discovery material without any risk of witness intimidation or harm to any individual's security," which, again, Brian Friedman has been very clear. They're not trying to threaten security. They just want to get to the bottom of the allegations and prove that they're false. And then they continue by saying, "With this order in place, Ms. Lively will move forward in the discovery process to obtain even more of the evidence that will prove her claims in court." What evidence could she possibly even have at this point that could help prove her claims? Like, how does she even win this?
It'd be tough. It's funny that they say even more, because we're still waiting to see the first. So show us the first amount, and then we'll get to even more. It'd be pretty hard, I think, at this point, based on what we're seeing. But who knows? I mean, there could be something out there that we don't know, but it'd be hard to imagine what it would be.
It's funny. I mean, this kind of reminds me of, a couple weeks ago when we had the Epstein files and the binder, and it was like this big prop and show about like, we got the files, and then everyone's like, there's really nothing in the binder, and then everyone's waiting for phase 2 of the next binder to come out. And I feel like that's kind of like what it is with Blake Lively's evidence, right? She's going to show us more. There's more evidence to come when we're waiting for any evidence, because so far it's been a lot of colorful storytelling, but there's not a lot of meat behind her allegations. So we'll see where she takes us from here. Just a reminder, guys, while I have you, please give Albertson and Davidson a follow, a subscribe on. Oh, I'm not even subscribed. Wow, that looks bad on me. There you go. I am now subscribed. 16.5 thousand subscribers, guys. Give them some love. Aldav Law on YouTube. You can check. They have Shirsty on. I've been on the channel. Dave Neal, who we love, has also been on the channel. So definitely give them some love and hit the like button if you're watching this right now. We have 2,000 people watching live right now. Laura says, I joined them. Thank you, Zach. Awesome. Rye says, can they get the phone company records to retrieve deleted messages?
There's two ways to get deleted text messages. One is directly from the phone companies, although the phone companies will tell you they do not store the text messages. At least that's what they tell you. And so getting a subpoena out to AT&T or T-Mobile or whatever, it's a nightmare to go through. The other way you can do it is you can get a hold of the device that had the text messages, an iPhone or whatever, and you can have a forensic expert actually go through that document or go through that
device.
Mm-hmm. Thank you. And they look for what we call ESI, electronically stored information. The problem, Zach, is think about your phone. Think about my phone. Think of everything we have on our phone. It's 99% of what's on our phone has nothing to do with text messages. So you're going to let some stranger, a forensic expert, go into a device and try to look for lost text messages. It's a very invasive request. And so you have to show that you really need this for this to go forward before a judge will allow it. But that if you really want the text messages, you can try getting them from the device through a forensic expert, or you can try to fight with them with the phone company. And that there's some federal laws out there that make it difficult to access information from these phone companies.
Yeah, I wouldn't want a forensic expert, accessing my naughty photos and naughty text messages. Those are private. So what is that? So when it comes to turning over the messages, right? Let's get back to Blake Lively and Ryan Reynolds, who are two of the defendants in Baldoni's lawsuit. What does willingly turning over their messages look like? I would imagine they don't want to turn anything over because they don't want to incriminate themselves. But what is that process? Because so far what we've seen from text messages are screenshots, and then we've seen these transcoded or transmitted messages that have been kind of retyped and presented in mostly Blake Lively's side of things. So would they screenshot them, or how would they even turn over these messages, and how would we even find out what would be relevant in this case?
So there's a couple of different ways to do it. When we work with our clients and have to hand over text messages, a lot of times we will work with these forensic companies that will at least capture the text messages, the relevant text messages, and they'll be able to encapsulate them in a way where you can send them over in native format, and it preserves everything that's there. That tends to be the best way to do it. It is a little pricey. Of course, in this case, they're not probably concerned about that. They've got the money for it. Not every case does. So sometimes if it's not a big case, you'll just screenshot it and you'll do it that way. All of that information goes to the lawyers, and the lawyers are going to look through it. And obviously they're going to figure out what to designate as confidential or attorney's eyes only, or whether it's even relevant, because sometimes a text message won't fit into the relevance of what's requested. And so those can be excluded. And then all of that gets numbered. We call it Bates numbering. So you actually number everything you produce, and then it gets produced over to the other side so that they can see it.
So what is the next step? Now that we have the protective order, we know what's going to be confidential, attorney's eyes only. Now we officially are moving into the discovery process, correct?
That's right. Yeah. So the next step is to get all the documents that both sides feel they need, and then depositions. And that's when things get fun.
And so I saw the timeline. It looks like depositions, there was a date listed for August 14th. Now, is that the deadline for depositions to be completed and submitted, or is that when depositions begin?
I think that was the deadline that the court wanted to see people ending, being complete with depositions. The court will move that, I'm sure. I mean, because they're gonna need more time. And typically you're supposed to be done with all of your depositions at least 30 days before trial. So I can imagine that the deposition schedule will change as this rolls out. What does that say there?
This is the timeline, and so it says August 14th depositions, fact discovery completed, and request to admit.
Yeah, so that would be all of the documentary evidence would need to be done. Depositions would have to be done, and request to admit would be where the parties come together and they agree on what is going to be admitted as evidence by stipulation of the parties. So there's some things that you don't have to fight over. You can just agree to admit it as evidence. And then they'll move on to expert discovery, and those are the expert witnesses.
Got it. And that'll come in October. So these depositions will be Blake Lively, Justin Baldoni, Jamie Heath, presumably Taylor Swift, or some of these other third parties. Would they also be part of these depositions?
Yeah, they're going to, whoever is a witness, certainly the parties' depositions are likely to be taken. And then who's ever a witness, you as a lawyer never want to put a witness on the stand at trial without knowing what they're going to testify to. So part of a deposition is to lock a witness into their testimony, which is sworn. It's under penalty of perjury. And then at the time of trial, if they stray from that testimony that they gave you in deposition, you actually pull that deposition transcript out and you ask the person, hey, do you, Ms. Swift, do you remember I took your deposition on this date, July of 2025? Yes. And you promised to tell the truth to me during that deposition, didn't you? Yes. And you did tell me the truth during that deposition. Yes, I did. Ms. Swift, I just asked you if the light was red and now you're saying it was green. Let me turn to your deposition testimony that you truthfully testified at. And you literally read it right in front of the jury and publish it to the jury. It's a great way of impeaching and controlling witnesses at the time of trial. Depositions, you can spend hours and hours with somebody, making sure you get those nuggets that you need from their testimony that you want to use in front of the jury, and also hold them to their testimony at that time. Because it boggles my mind, Zach, that witnesses show up to trial and change their stories. It happens in every case, and I'm always kind of like perplexed by it. Like, why are they being serious? Are they just making a mistake? Or are they really trying to mislead the jury? But in all events, you're going to have that deposition transcript. And here, you're going to have a videotape that you're going to play that's going to be synced to that deposition transcript. And it's going to be very powerful for the jury to see, especially if somebody strays from the testimony they gave at their deposition and they're testifying differently now at trial.
Yeah, we saw that with the Gwyneth Paltrow trial, the ski trial, with the guy who said that she jammed into his back and he went flying 20 feet in the snow. Which, ultimately Gwyneth Paltrow came out victorious from that trial, but that was fun to watch and to see the inconsistencies of people's stories once they get on the stand. Laura says, can depositions be made public, or is this under attorney's eyes only? So will we have any sort of information about these depositions prior to trial, or do we have to wait for this to potentially go to trial first?
They could be made public by the parties. Any information where there's questioning on information that's attorney's eyes only would be redacted from the deposition. And that's what makes it a little difficult for the court reporters. I know we had a comment on one of our videos from somebody who'd been a court reporter for years. And this person said it's such a pain in the rear to have to deal with attorney's eyes only depositions because you have to literally redact portions of it. Right. But that's what they would do. It is live questioning under oath. I mean, it's not, the deposition in and of itself is not, confidential, except for those portions where they're talking about that type of information. But it's not as if the public can just go up and get a copy of the deposition. One of the parties would have to make it available.
And so is there a chance that we will see these be made available?
I would think so, based on what's happened so far. I mean, they haven't been shy about making other things available to this date. So I would think so.
Yeah, I would think so too. I mean, and is there a chance that we see these depositions should this not go to trial?
I mean, if you go to YouTube and look for old deposition transcripts, you'll find them. And somehow or another, they end up there. How they end up there, I don't know. So unless there's a court order that says that you cannot disclose these deposition transcripts, I think that at least portions of them are going to be put out, especially the segments that support a particular party. Those are going to be put out, and everyone's going to claim victory based upon the testimony.
It's going to be interesting because we're really going to have he said versus she said, because Blake's going to have to stand by what she claimed in her initial complaints. And so far, we've seen the stories change. We've seen it specifically with the video footage. We went from a 3-sentence allegation to suddenly it was a very colorful, multi-paragraph detailed explanation of what happened once the footage was actually released. And suddenly it went from there was no audio recorded to there was no audio that was needed to be recorded, but there was audio recorded. So we've seen the story kind of change a bit. So I'll be curious to see what happens. Okay. I want to talk about the subpoena with the New York Times and get an update on the New York Times case. But very quickly, before we get to that, I do want to give a quick shout out to this week's sponsors. First up is Pair Eyewear. I'm wearing my Pair Eyewear right now. When you refresh how you see things, the world can be a more vibrant place. Just in time for spring, Pair Eyewear has 3 new colorways for the most iconic acetate base frames. Take a peek at their new Cozy Honey, Soft Lavender, and Moody Gray frames. And don't forget that you can soften or bolden your look in a snap with the endless collection of top frames. I have some top frames right here. Look at if I want to go from indoor to outdoor. Look at that. Boom. Evening, daytime. Quick, easy. Base frame started at just $60. And your FSA or HSA could also help cover your prescription eyewear. Plus, you get 15% off if you use code NOFILTER at paireyewear.com. Base frames start at just $60 and top frames start at just $25. Free shipping on all U.S. orders. You can also use their virtual try-on to try on your glasses before you make your purchase online. Free returns and exchanges within 30 days, no questions asked. You can also save with pre-tax FSA and HSA dollars. Upgrade how you see the world and how the world sees you. Go to paireyewear.com and use code NOFILTER for 15% off your first pair. And you can always support the show by mentioning No Filter with Zack Peters sent you in your post-checkout survey. That's Pair Eyewear, P-A-I-R, paireyewear.com, code NOFILTER. Boom. And then also some love to my pals at Thrive Market. It's crazy that there are over 10,000 chemicals that have entered the U.S. food supply, yet the EU limits this to just 300 additives. I personally don't have time to be sifting through all the different ingredient labels to see what's in my food, which is why I love using Thrive Market. Thrive Market makes it so easy to find better options without the hassle. One of my favorite features is their Healthy Swap scanner in the Thrive Market app. So download the app. It's simple. You just scan an item and it'll instantly suggest cleaner, healthier grocery alternatives. And the best part is everything gets delivered right to my door and I get savings on every order. Thrive Market takes the guesswork out of finding safe, healthy food. All their products are 100% non-GMO and free from over 1,000 harmful chemicals. Super easy, super convenient. They have tons of my favorite brands. Owen protein shakes, Chomps meat sticks. I've loved those. Those have been some of my partners in the past. And the fact that I can get it all in one place like Thrive Market is a fave of mine. So if you're ready for a junk-free start to your 2025, head on over to thrivemarket.com/nofilter and get 30% off your first order plus a free $60 gift. That's Thrive, THRIVE, thrivemarket.com/nofilter. thrivemarket.com/nofilter. All right, let's get back to the show because we have lots to dive into. Paula wants to know if Blake Lively used a fake subpoena, will she go to jail? That's so sneaky. Okay, so let's get into the New York Times and this subpoena that they claim they obtained to get these text messages between Jennifer Abel and Stephanie Jones at Joneswork PR. So we know Joneswork PR used to represent Wayfair and Justin Baldoni. Then at some point, Baldoni hires Melissa Nathan, who's Crisis PR. Jennifer Abel's his direct contact at Joneswork PR. Stephanie Jones is the one who owns Joneswork PR. Now, they part ways. Jennifer Abel leaves Joneswork, stays with Baldoni, stays with Wayfair, continues to work with Melissa Nathan. Then at some point, Stephanie Jones has communication with Blake Lively and her team. And then there's this CRD complaint that comes out and is published in the New York Times. It's been reported that the CRD complaint was filed on December 20th. The New York Times article was published on December 23rd. So is it possible that they really did use a subpoena to obtain those text messages? Or could Stephanie Jones have voluntarily offered up this information? Because technically, the phone that was used to send these text messages was a company phone, which Stephanie Jones owns under Jones Work PR. So she owns these text messages, but I think there's a lot of confusion as to how the text messages were provided to Blake Lively's team and then presented in the CRD complaint and the New York Times.
Yeah, and Stuart and I were looking at this just this morning because we're mapping out all the different dates when different lawsuits and things were filed, because we're trying to figure out where was this subpoena issued. In order to issue a subpoena, you have to have a pending lawsuit. That's what gives lawyers the ability and the power to issue a subpoena. Now, agencies like the CRD can issue a subpoena, but not parties that are part of a CRD complaint. And I don't think the CRD issued any subpoena in this case, but you have the CRD complaint was filed December 20th. The New York Times article comes out December 21st. And the CRD complaint already had all the text messages in it when it was filed December 20th. I don't know of any lawsuit that was filed by that time. You have the Jones versus Abel lawsuit filed December 24th. Okay, that's after the CRD complaint, after the New York Times. You've got the lawsuit by Lively filed December 31st. After. It's still after the CRD complaint. You have the Jed Wallace lawsuit filed in Texas. That's not filed by Jed Wallace until February of 2025. Now, Blake Lively did file something in Texas State Court on January 21st, still 2025, still after, where she's trying to get pre-lawsuit deposition of Jed Wallace. That ultimately gets dismissed, but still, it's well after the CRD complaint and the New York Times. So I can't find any lawsuit that was pending at the time prior or around the time that the CRD complaint was filed or the New York Times came out. So it still begs the question, what subpoena are they talking about? Now, it's possible, like I could right now sit down and draft up a subpoena and I could give it to you, even though I don't have a pending case. And you can say, sure, I have no problem handing over these text messages, and I'm handing them over based on a subpoena. It's not necessarily illegal. I mean, there's nothing wrong with lawyers reaching out to witnesses and getting information. The weird thing about it is Stephanie Jones worked for Wayfair. And so it's one thing if she's under a legal compulsion by way of a subpoena to hand over those documents. It's another thing if she just voluntarily hands them over. It just seems a little odd. And we're having a hard time figuring out where's this subpoena coming from.
Or if it's even real. Which, I mean, it kind of sounds like that's what they did, was her attorney reached out to Stephanie Jones, which I actually think it was the other way around. My personal theory is Stephanie Jones is likely the one that spearheaded all of this. She collected all of this information, presented it to Blake Lively's team to convince them that there was this alleged smear campaign. Like that to me sounds the most plausible, because it's just, how would Blake Lively be aware of some, nefarious alleged campaign to take her down outside of just a viral moment of her, being disliked on the internet, which has happened in the past, maybe not to that scale, but she went viral on the internet. It happens to a number of different people, and it's usually not necessarily an orchestration of a smear campaign. It also doesn't make any sense that Justin Baldoni, during the promotion of his film, would try to harm the reputation of his lead actress, especially when he already had the rights to the second film. So there were clearly plans for him to not just make the first film, but to make the first film so successful that they get picked up for a second film. So it doesn't make any sense why he would try to hurt the movie, or why he would try to hurt Blake Lively specifically, because she's the face of the film. The whole film is based around her. And the second book by Colleen Hoover, it starts with us. She's Lily, the character Lily is more of the forefront than Ryle is. So I would imagine Blake Lively would be vital in the case that there should be a sequel. It just doesn't make any sense, but it does sound more plausible to me, at least. And it does make more sense that Stephanie Jones, who just lost Wayfair, who just lost Justin Baldoni, who now has this cell phone that belongs to one of her former employees, she's upset because we just saw the success of It Ends With Us. And so therefore you're losing out on all of that money. My understanding is we've heard that Stephanie Jones was losing a lot of clients recently. And so it wasn't, her company wasn't doing the best that it had done in the past. And so when you lose a big film that's part of a book franchise, and obviously book franchise, thank you Reese Witherspoon, have completely blown up when it comes to creating television series or new films. So adaptions are really popular right now. It only makes more sense to me that Stephanie Jones had more of an intention to spearhead this, but we're not really hearing much about her. It's really just Blake versus Baldoni at this point.
There is one other issue with the subpoena, and there's built into the litigation process is this idea of fairness and notice. And so just because you have the power to issue a subpoena because a case has been filed doesn't mean you can just secretively send it to somebody and get all the information. You have to give notice to the people that are subject to the contents of that subpoena. So if I'm going to be coming after your text messages, Zach, I've got to give you the opportunity as a non-party to either object to that, or for parties to actually file a motion to quash, which is a motion to do away with the subpoena because it's overbroad or it's asking for irrelevant or private material. And so there's a second component there. The New York Times seems to just state, oh, there was a subpoena. Okay, well, that begs the question, which case? And then if you could even show there is a case and that there was a subpoena that went out, was it properly noticed to everybody so everyone had a chance to talk about this? Because these text messages, there was a lot of them, and we don't know exactly, did the New York Times disclose all the text messages? Apparently not. Brian Friedman has done a good job of putting together a book of text messages that we can all look at that are filed with the court. But are there any other text messages that were retained? And it's not lost on me that these text messages could include highly personal and intimate information. And we now have Blake Lively saying, hey, text messages like that shouldn't be disclosed. But yet this text messages from Baldoni and his crew, that wasn't given the same treatment, wasn't given the same deference. All we hear is, well, there was a subpoena and we got this stuff. Well, what if this protective order that we just talked about had been in place at that time? Here, at least you would have had to give Baldoni's lawyers a chance to look at these text messages and determine, is this a trade secret? Is this a security measure? Is this a medical piece of medical information? Or is this highly personal and intimate information, whatever that means? But Baldoni's team wasn't given that. Apparently they weren't given that. And so all these text messages were just wholesale, apparently, given to the New York Times. That still begs the question, who gave them to the New York Times?
Right.
Everyone has their ideas on who did that, but the protections in place for Blake Lively and her team right now apparently don't apply to Justin Baldoni when his text messages are being given to the New York Times.
Correct. Now, does Jennifer Abel, being that she did work for Jones Work PR and this was technically a company phone, so all of those text messages and that phone are technically company property. Does this still entitle her to those same protections, or would Jones Work be able to waive that because technically they're the owners of these messages?
I would have to think that Abel would have some right to privacy in those text messages, even though it's a company phone. I also think the Wayfarer and the Baldoni parties have some right to protection about those text messages. And it's not necessarily just the right to privacy, although I think that's a big part of it. But there could be contractual obligations too. I don't know what their contract is, but I would think if I'm hiring a PR company, one of the things I'd want in the contract is you're not going to talk about me negatively, either during the representation or after. And if this was a lawyer, we would never be able to get away with this, because as a lawyer, you cannot disclose confidential information. And so the fact that this happened, it just kind of blows my mind a little bit.
Not only that, but I also kind of feel like, let's just say that this was an alleged smear campaign. Let's give Blake Lively's team the benefit of the doubt and say, you know what? Yeah, it was a total smear and they were leaking things to the Daily Mail and they were planting stories. Even if that is true, that to me, those sound like trade secrets. Those sound like an actual business plan, business model, marketing plan, whatever, that would technically be considered confidential by the rules Blake Lively wants to play by.
Yeah, absolutely. And I think that goes to Stewart's point of, it's interesting that they didn't want to give the Baldoni side the benefit of this protective order, but of course they want those protections for themselves.
Which tells me they don't have that strong of a case if they're going to continue to fight for these things. I mean, and we know, or I at least can predict, that they will likely be abusing that or trying to really push that fourth attorney's eyes only category for highly personal and intimate information about third parties, because I feel like that's a little vague, that they can try to stamp attorney's eyes only on a number of different things that I think may present an uphill battle for Brian Friedman. When do we get an update on the New York Times lawsuit? Because they're trying to get dismissed, and Leslie Sloan is still trying to get dismissed. Do you think with this subpoena piece, do you think that the New York Times will get dismissed? I know last time we spoke, we seemed to think that they had a strong enough case that the judge may allow them to get out. But I mean, now that there's a lot more attention on this subpoena that may have been a misrepresentation of what actually happened, do they still have a strong case to get dismissed?
I think the ball is still in Brian Friedman and Justin Baldoni and Wayfarer's court right now. And that is, are they going to just simply do a second amended petition, or are they going to oppose the 12B6 motion filed by the New York Times to get the case dismissed? So nothing so far. We don't know which way they're going to go on that. The judge told them those were their, if they wanted to hurry this along, they had those two opportunities and they could do that. So there's strategic reasons why you would want to go down one road, and then there's strategic reasons why you'd want to go down the other. But as soon as something comes in, then we can report on it. But the judge did seem to be siding with the New York Times based upon what he said. And that's because the law is so strong in New York for reporters. And we want a vigorous press. And, people have picked up on this, Zach. It doesn't make common sense that the New York Times should be able to do this. In fact, the New York Times didn't even have to ask Justin Baldoni for his side of the story. Everyone's making this point that, well, he was only given 14 hours or whatever to respond. Under New York law, you don't even have to ask him to respond. Now, they do that to check the box. I think you've pointed this out in previous videos. They just did that to say, hey, we checked with Baldoni and his team, and we didn't hear anything back, or we did hear back. But they didn't give him adequate time, but they're not required to do that. So I do think the judge here has signaled that Baldoni's team is going to have to do something good with the second amended complaint to keep the case on against the New York Times.
Yeah, I think they argued that if anything, they were doing him a favor by even allowing him to comment on this article because they don't have to. And they're like, well, technically we went above and beyond to give him a chance to comment on this. We didn't have to give him the 14-hour window, but that was just us being gracious to his side because we don't have to cover it. And they got out from the reporter privilege, but then also from the, news opinion privilege, where they're just like, well, we called it a smear campaign, but that's just our opinion. And we don't have to disclose to the public what's specifically our opinion and what's not our opinion. We can just present it, and it's kind of up to them to figure it out. But I think it really exposed the New York Times. It may not be able to, keep them in this lawsuit, but it exposed them in a way that I think is really going to hurt their credibility.
Yeah, they don't look objective, that's for sure. I predict there's going to be a second amended complaint by Baldoni. If I was in his camp, that's what I would do.
For sure. Leanne says, does the metadata make any difference to the New York Times motion to dismiss? I would assume that that's the URL that was found with the images and the dates of when those images were uploaded to the New York Times server.
It could, because to get the reporter's privilege, you have to be commenting on a complaint or something that's going on currently. And so the argument for Team Baldoni is, hey, this article started in October and was worked on for weeks before the CRD complaint was even filed on December 20th. Therefore, the protection shouldn't apply. It's a gray area. Does the protection apply if the New York Times is or any publication is commenting on a case that's going to be filed? It's a gray area, and it'll be interesting to see what the judge does with that.
Yeah, because they're basically saying the New York Times argument, from what I remember, was that this was just a bunch of internet sleuths, and this information that they're presenting isn't even accurate information. I'm like, first of all, that's rich to call out the internet sleuths when you've been exposed with your pants down. So let's, dial it back a little bit. Number one. And number two, well, then let's find out if the metadata is real, or if the URL, like if there's nothing to hide, then let's investigate that and find out if that's legitimate and see what the judge determines in terms of, the timeline. Because I mean, I wouldn't imagine that she would, the CRD complaint really just seems like a protection to make sure that she couldn't be sued for making these allegations, because they would be filed legally without her even needing to move forward with the lawsuit. And if it was a PR play, then the damage was already done from the get-go.
Yeah, that's what it seems like. I also would say that the metadata could go to the issue of collusion, because the reporter's privilege doesn't apply if the reporter colludes with the subject and they had, some ulterior motive for making the story. So that would be an interesting argument as well.
Yeah. So what's going on with Jed Wallace? We have his case in Texas. Have we heard anything about his case against Blake Lively? My understanding is she's trying to move him from Texas to lump him into this New York lawsuit. And he's kind of fighting back, saying, no, you served me here in Texas, so I want to litigate this here in Texas.
Yeah, there's not a ton going on. I actually looked it up. It's filed in Texas federal court in the Western District for Texas federal court, and he filed his complaint on February 4th. Before he filed his complaint on, I believe it was January 21st, Lively filed in Texas state court trying to trigger a statute in Texas, Rule 202, which is unique to Texas, where you can do pre-suit depositions even before you file your lawsuit. But you have to get court approval to do that. You have to have a court order. She withdrew that. And the reason she, in her withdrawal of that, she said that she did it for judicial efficiency because of the lawsuit that's pending in New York. That was her reasoning for withdrawing that. But she let that go, and then Jed Wallace sued her in federal court. As of right now, she hasn't even answered that complaint, and it says that her answer is not due until April 4th, 2025. So as of right now, the complaint has been filed. It's only a 10-page complaint. It's not that long, but we'll have to wait and see by April 4th what Blake Lively does with that and whether she's going to try to have it removed to New York, have it dismissed, or just answer.
You know, the thing that's interesting about the Jed Wallace case to me is they're asking for $7 million. Why $7 million?
Yeah.
I mean, why not 10 or 5 or
200?
What's 7? I don't know what the $7 million is. So we got to find out about that.
Yeah, that is interesting. I predict that she's going to settle with him. I don't think she's going to move forward with litigation with him in Texas. I think her priority is fighting this in New York, and I don't think there are enough people talking about Jed Wallace, at least not publicly, that there's not enough of a reason for her to give it much attention. Terry in the live chat says, can the CIA delete, I'm assuming, text messages from the Apple iCloud? So I also want to clarify that the CIA guy, this guy, the Shapiro, that has been hired for Blake Lively's team, he's not current CIA. He's a former CIA agent that now works as an independent contractor to help with crisis PR. So he's a crisis PR guy. He may have some sort of contact still at the CIA, but he certainly doesn't have the same pull that he had when he was with the CIA. So I think he sounds a lot scarier than he actually is. What's your take on Shapiro?
Yeah, I don't really know that much about him. I think if he's former CIA, I would agree with you. He probably doesn't have the power that sounds scary, but I strongly suspect that he's probably does not have the power that people think he has. But he might have some really good experience. He might have some good contacts. He might be great at what he does in terms of the PR world. I don't think that they'd have the ability to just start deleting text messages off of Apple iCloud. But what do I know?
We're not in the CIA, so what do we know? But also at the same time, I think a guy like Shapiro, I was just talking to Andy from Popcorn Talk, and he was telling me about this Airbnb situation where Airbnb utilized Shapiro to hide, crimes that were happening at different Airbnb, locations. And so there was some big cover up that he was allegedly participating in. But my thing is, the reason he's able to get away, if he truly did do what's being reported, if he really did do that, the reason he was able to be successful at that is because a guy like Shapiro is only able to really thrive when he's hiding in the shadows. And at this point, he's been fully exposed. His name is out there. People are digging up everything they can. They're screenshotting his LinkedIn profile. So there's not a whole lot of work that he can do because the spotlight is on him now. So Shapiro, I don't think, has the same pull that the same bag of tricks that I think he normally would have. Because even right now, if people are like, "Oh, this creator's content is starting to dip," could that potentially be Shapiro doing some work at TikTok? So I think there are too many eyes on him to make him fully successful.
Yeah, that'd make it a lot more difficult.
Yeah. Let's answer a couple of questions that people sent in on Instagram, and then I think we're pretty solid. Appreciate you guys coming back on.
Oh, absolutely.
Okay, let's see what we got here. When does Blake need to reveal her alleged witnesses to testify by? So she spoke about these two other actresses or cast members on the set of It Ends With Us that she claims are going to come forth with their stories about being uncomfortable around Justin Baldoni.
Well, according to that sheet you showed us earlier, between now and August 14th, all fact discovery has to be completed. So that would be discovery that will be going out on the Baldoni side, where they're going to ask her to identify all witnesses that support her claims. And that's when they're going to get the list of witnesses, and then they'll start the depositions.
And so there wouldn't be any protection against releasing their names, right?
No, I mean, you have to state what witnesses you have, and that's true of every lawsuit. That's one of Stewart's favorite interrogatories that we do in California.
Amy, thank you for becoming a member. Redondo Beach says, good morning. You and Donna are my faves. When is the live show? Also, this lady just applied for law school. Congrats, Redondo Beach.
Nice.
Great.
Kimberly just became a member on YouTube. Welcome, Kimberly. AKA the cat lady says, since Blake is claiming emotional damages, does that open her up to an expert assessment from someone on Baldoni's team like Amber Heard had?
Yeah, this gets difficult. So it potentially can, but likely won't. So she is making claims though, and it does lead one to think, are there medical records from a psychiatrist, psychologist that we need to see? And this is what attorneys do. So Brian Friedman and his team, if she's claiming emotional damage, we want to know, was she emotionally damaged previously? And are we just dealing with her current emotional damage and we haven't added to it? In other words, we need experts to come in and say, she was so flawed and so bad before, we really didn't do anything that we're responsible for. And of course, this is very, very private information. And judges take the psychological record request very carefully. The fact of her actually, Blake Lively having him to go sit in front of an expert doctor that's against her to do some type of independent medical exam, I just don't see that happening. That is so intrusive into someone's rights. But maybe they ask for it.
I mean, yeah, and also I just feel like the SNL thing, and then we have her at South by Southwest, that I think these instances don't necessarily show this emotional distress that she's even claiming, when she's continuing to put herself in the public light, and how promotional things work for films. Like, one, they're usually, EPK interviews that are done well in advance that they could use to promote the film. So Blake Lively likely did some promo interviews while they were filming Another Simple Favor that could likely be used now. And sure, maybe she may have to show up to appear on the red carpet to pose for a photo, but all these other pieces, I don't think, her cracking jokes on stage and her doing selfies and the amount of press that she's doing, just to me kind of feels strange.
Right.
Doesn't make a ton of sense. Which also, by the way, this came out this morning. Sharon Stone, who I guess was hired to star in Another Simple Favor, just came out, and she's saying that she was unexpectedly dropped for no reason from Another Simple Favor, which is Anna Kendrick and Blake Lively's new film. So interesting. I know Paul Feig, the director, has been very outspoken, which I know he's trying to defend Blake Lively. But I guess from your, expert opinion, we have people like Ari Emanuel who came out and said their team, Blake and Ryan, ride or die, and they fired Justin Baldoni at WME very, pompously and confidently, saying that they fired him, and then even mocked him by saying Justin Baldoni, baloney, I don't know what his name is. And then now we have Paul Feig, who's the director of Another Simple Favor, who's coming out and trying to defend Blake, as is his wife, and a bunch of screenshots from Instagram comments that we've now seen. I think these people think that they're defending her, but I feel like they're actually harming her case more. I mean, how would you guys feel if you were representing Blake and you have people like Ari Emanuel and Paul Feig that are publicly speaking out in support of her?
Well, I think the Freakonomics recording of Ari Emanuel will definitely hurt Lively. I mean, I think that's evidence for Baldoni that not only was I dropped because of Ryan Reynolds and Lively, but look how I'm being mocked. This is exactly what I'm saying, is that I'm being disrespected. I don't have the same status in the industry that I once had. Here's a very powerful agent literally mocking me in front of a group of people. I mean, that is not good evidence for Lively. That's definitely good evidence for Baldoni. Paul Feig, that might be a little bit different. I mean, he did have a movie, and that movie didn't necessarily directly harm Baldoni. But, I mean, Emanuel, he literally dropped Baldoni. I mean, that has to be one of the damages.
Yeah, I mean, but also, Paul Feig speaking highly of Blake Lively, I think also kind of hurts the emotional distress case that she's trying to make by saying that, she can't work. She, her family is traumatized as a result of all of this. And then Paul Feig's like, no, everything's great. Look I'm taking selfies with Blake Lively and Anna Kendrick. They're in the same photo. They're not feuding. There's no tension here. I think that doesn't necessarily help her emotional distress case.
That's true. Yeah, that's true.
Knath on Instagram says, do you think that they will settle, or And if so, how will they work the SA claims into it?
Yeah,
well, I guess it's not SA, it's SH. It's harassment, not assault.
Yeah, it's SH. That's correct. Yeah, they've got to settle this case. I think both sides need to settle this case. We're only at what, day 60 something. Baldoni has clearly won in the public opinion polls. Like, cash in on that. Get the settlement now. And Blake Lively and Ryan Reynolds, they have to settle this. And I've said to you, Zach, and people don't like that when I say this, but this is painful for everybody, and it's painful for Ryan Reynolds. I mean, he's seen his brand drop. And then Blake Lively, is she going to work again? Who's going to work with her? These are all issues, and just lawsuits themselves. They're like being dragged across concrete. It's no fun for anybody. There are people that have done some things wrong here, and it's and Keith, I've talked about this. It sounds about right. $150 million in cash and a public apology. I think this case gets put to bed, and then people can start rehabbing their reputations.
Yeah. Mel in the live chat says, Ari Emanuel mocked and fired Justin Baldoni on record. It's an amazing recording for Justin. I also want to note about that it wasn't just, a Q&A in a theater amongst a select group of people. This was done and said under the impression that this was, even though the audio and the video ended up disappearing and there was, a rare tech issue that has never happened before. But despite that, this was done with the impression that this was going to be released under the Freakonomics podcast feed, which is a very large podcast. So Ari Emanuel was very much under the understanding that this was going to go far and wide. And he said this on record, despite, obviously the audio and footage was lost until it got, an iPhone recording was leaked online. But he did this. And he also said in that interview as well, I knew that you were going to ask me this question. So that also shows that this was a premeditated answer. He knew that he was going to be asked about this. And so unlike Anna Kendrick, who avoided the questions about Blake Lively on the red carpet, she kind of avoided it by throwing ayahuasca into it. Ari Emanuel was very clear that this was going to be asked of him, was very clear that this was going to be recorded and broadcast at some point.
And he didn't equivocate in his answer. He was very strong in what he was saying. And that's exactly the type of damages that Baldoni said that he suffered.
Mm-hmm. So as much as they think they're helping Blake at this point, they're hurting her a lot more. Tam T says, will Blake go broke if she loses? I mean, I think that's why she probably has to settle now, is to avoid, hemorrhaging any more money. I don't think that this is looking good for them. Gma0152 says, what are your thoughts on how the New York Times got the CRD complaint? Because, the CRD complaints, my understanding is that they're confidential. So the only way they would obtain a copy is if somebody directly provided it to them.
Yeah, it had to be the Lively camp. Somebody on the Lively camp gave that to Towie at the New York Times in order to report on it. And, again, that comes back to what was the strategy here? Why would you do that? Well, you would do that in order to have a PR assault and offensive. And that's what they were doing. And, I don't know the mechanics behind what they were doing, but if I were to, now having seen all this, if I were to come up with a strategy of how to do this, I'd file a CRD complaint in California, get the litigation privilege, report it in New York, get the reporter's privilege, boom, you're golden. And that seems to be exactly what happened here.
But they weren't expecting Baldoni to fight back.
Yes, no, not to that degree. And they also were so shocked by the video of them dancing. I mean, again, I always talk about how, in my mind, that's some of the most damaging evidence against Lively. I mean, they had no idea what he had, and they didn't realize that he was going to come out so strong.
Well, I mean, based off of everything we've heard from him from the set, he seemed to be, buckling to her every need. And so I think they just expected him to continue to be meek in her presence. And this was the one time he decided he wasn't going to do that. And then there's I don't know if you guys saw it, there's, I guess it's not new, but it's newly surfaced footage, paparazzi footage from the set of It Ends With Us. And it's the two of them making out. And she's biting on his lip, which also is contradictory to the harassment claims where she says he was also biting, or he was sucking on her lip, and that made her uncomfortable because it wasn't pre-coordinated with the intimacy coordinator.
Yeah, I did see that. I mean, that was shocking. Just shocking.
It's funny. This seems to be a theme with her where she gets to set the rules and she doesn't have to play by the rules, but everybody else is expected to play by these rules.
Well, it's worked for her and Reynolds in the past.
Yeah.
So,
and,
why change now?
What are the odds of this actually going to court? What would you guys, if you could take a bet right now, what do you think the odds are of us actually seeing a trial come March?
10%.
10%. Wow. Yeah. Do you think we even get to the deposition phase?
I wouldn't be surprised if you see a few depositions. I mean, most cases that you need to take 1 or 2 depositions at least before you can settle. But I would be surprised if they go the distance and take every deposition they could take. There's going to be a lot of witnesses here. It's going to be a lot of depositions.
Yeah. And by the way, Zach, I don't want to disclose this to our competitors, but we are scared to death when our clients' depositions are taken. And the reason is because we as lawyers have to shut up, which is very hard for us to do. And we have to let an untrained individual answer very technical questions at times, or questions that could sink their case. And so we're sitting there at deposition and we have the best poker face on that we can get. And we'll get we'll get a question that inevitably will come up, and it'll really hurt our case if our client answers wrong. And you're just sitting there with the best poker face you have, just dying the death of 1,000 cuts until the client answers. And generally they answer correctly, but when they don't, it's devastating. And that's why I think Keith's saying we might get to the deposition phase here, because you never know what Baldoni testifies to under pressure or what Blake Lively testifies to under pressure. And that actually helps cases settle is when people make mistakes in depositions, because that's sworn testimony that can be used at the time of trial to impeach you. Boy, that can be devastating.
I mean, not only that, but I would also imagine, one, she hasn't been consistent with her story, which is, I think, the biggest challenge that she poses right now, or that's posed against her right now. But also, I think the hard part is a lot of the allegations she's made happened when they were on set and there were cameras, as we saw with the dancing montage. And Brian Friedman has not released additional footage, especially with like the birthing scene where she says there was a tiny cloth that was covering her, and Friedman's like, actually no, she was wearing a fake belly and she was wearing black briefs. And she says, well, I was asking repeatedly for somebody to bring me a covering. The footage exists. The footage is there, and Baldoni owns all of the footage, and Blake doesn't know what was specifically caught and what wasn't, because she didn't realize that there was audio in that dancing montage, because she very clearly said there was no audio being recorded initially. And then Brian Friedman said, well, guess what? Surprise, here's the audio. Baldoni was wearing a mic unbeknownst to you. So it's going to be interesting, because they've watched that footage a bunch of times and they know exactly what flaws are in her story that they're going to ask her about.
Well, remember too that jury trials are about truth telling and credibility. And Brian Friedman is going to be able to show that more than likely that Blake Lively was not credible here, at least in the way she remembered something. Maybe she misremembered it, or maybe she's lying. The point being, there's a jury instruction in federal court that will likely be given to the jury by the judge that will say, if you disbelieve somebody on one point in their testimony, you can discard their entire testimony. And so if you're Brian Friedman, the strategy you're doing is to take her credibility away during the entire trial, from opening to closing, getting her on the stand, show that she's not a credible person. If you can get the jury to believe that, I think she loses.
I mean, the audio and the video, I think, is damning. The birthing video of Jamie Heath and his wife, also damning, that she, reported that as pornography and saying that he was showing nude images of his wife, which, like, technically, yes, but it's such a miscategorization of a home birth still shot of a woman holding her baby where there's no actual nudity reveals. She's technically nude in the bathtub or in the water pool, but it's such an egregious misrepresentation of what that very wholesome moment was that I think she's already shot her credibility a number of times.
Yeah.
Last question from Amy Shepard. Do you think it would be a benefit to our future legal system if the New York Times case was not dismissed and it actually changed the future for legacy media to be held more accountable? Loaded question.
It is a loaded question. I mean, I think on the one hand, I would say it'd be nice to have reporters be held a little bit more accountable, because I think that what we want is we want to know that the news stories we're reading are fair and balanced and objective to the extent they can be. And, you can't always do that, but that's why you file a report and then you do another report and then you do another report. And as we've said before, you follow the story as it unfolds and you follow it to the end. It just doesn't feel like that's what's happening here. And it would be nice to have some mechanism to hold them accountable. On the other hand, the fair reporting privilege has a good, it's good when it's used properly. And we do want reporters to be able to report on court cases without being sued every time they report on a court case. So it makes sense that we have that rule. But as with every rule, it can be misused at times and end up in unintended consequences. But I like the sentiment of that question, which is, wouldn't it be nice if our reporters were held accountable? Yeah, I agree with that. It would be nice.
Well, and I'll just add that I think they are being held, the legacy media is being held accountable now with places like, you can come to Zack Peter, Dave Neal, you can come to our channel. There's a flattening of reporting that's going on. I mean, this was not happening 10 years ago, 5 years ago. And so people have other sources that they can go to and listen to. And I think the legacy media, they're losing subscribers. A lot of people have said that they're not going to read the New York Times anymore. I don't know if that's actually coming to fruition, but you would like to think that if the New York Times had reported on such a big story that they worked very hard to put together, and then they just went silent. Reporters should be reporting on this wherever it goes. Seek the truth, be transparent, give disclosure, and that's just not happening.
Yeah. So I think, the real accountability might not happen federally or legally, but it's definitely happening with the people. They're not subscribing anymore, and we're seeing more and more of these traditional news agencies that are now starting to put up content behind a paywall because they're bleeding in advertiser money, because advertisement agencies don't care to work with them because they're not bringing the numbers that they once did. And so I think that's definitely where we see it. What do you guys think of the critiques that many of us are getting in regards to saying that we're only covering this story because we're trying to grow YouTube numbers and trying to, gain engagement fish on this case? Which, to me, I've made the argument that this is a modern day Menendez brothers, a modern day O.J. Simpson, where it's a highly publicized case where the public wants information and they would have been glued to their television screens 20 years ago watching these trials unfold on the news. And we would be no different from all of the reporters that were standing outside of the trial, or in your case, you guys would be on the local news stations as the expert, weighing in on what's going on with the latest update in the OJ trial. So it's just modern day. It's just playing out on the internet, and legacy media is just upset that they're kind of losing the trust of the public, which I think is their own doing.
Yeah,
what are your thoughts?
Yeah, and go back and look at, every video that Zack Peter did. Does every video get 100,000 views? No, but he's there. He's doing, you're doing what you do. We're doing what we do. We enjoy covering this material. And now it's been fun to have a larger audience join us and go through it with us. But we also cover other topics, and we also talk about other things. And it's because we enjoy kind of bringing the legal perspective to it, for you, bringing all your experience and to these topics and your knowledge of different things that have happened, especially in pop culture, that's so valuable. So I don't agree that we're doing it just for the likes or the clicks. I think we're doing it because this is what we do and we enjoy doing it, and we bring a unique perspective to it. But it's not like the New York Times is publishing articles for free. They're trying to make money too. Yeah. And so is every other news outlet. So, there's always a business aspect to doing these things, because there has to be, because otherwise how are you going to support yourself? So it kind of those statements kind of fall flat with me.
Yeah, I agree. All right, guys. Thank you for coming back on the show. Guys, please be sure to give a follow and a subscribe to Albertson and Davidson LLP on YouTube. Aldav Law here on YouTube. Be sure to subscribe. We're at 16.5. Let's try to get them to 20. Get them to 20 soon. Please show them some love. Support them. They break these things down. They go through the legal documents themselves. So be sure to subscribe. Hit the notification button. That way you're always up to date with the latest on them. Are there any other cases that you're covering right now outside of Baldoni? I know you've covered a few in the past. You've covered the Girardi stuff, which is how we first got connected.
Yeah, we have the Girardi case. There was the one case. God, I'm blanking on the name. The Brian. Yeah,
The guy out of Idaho
that killed the 4 college students. That was a horrible case. And so we've been starting to cover that. And we have a number of other cases that we're going to start looking at based on comments and, your video and our videos. And so we're going to start taking some of those comments to heart and covering some more legal matters. Yeah.
Are you guys thoughts on the Menendez brothers?
It is crazy. I haven't looked into it that far, and I haven't looked at the legal filings yet, but it is interesting. And I guess now the new DA is coming in and saying that they shouldn't be released. I mean, it doesn't seem to me that the Menendez brothers are dangerous to society at this point in their lives.
Yeah.
But that was such a sensational trial at the time it happened. I remember it happening. Yeah. And it'll be interesting to see if they're going to be able to win their freedom. I doubt it. It doesn't look good for them right now.
Yeah.
It'll be interesting to see what happens.
Yeah. All right. Also, you guys should cover the Diddy trial. That's picking up steam right now too. That's another one that people are really interested in. But I will let you get back because I know you got tons of clients that I'm sure are blowing up your email and your phone, wanting some attention away from Blake. So, thank you guys. I appreciate you guys. Thank you for listening. Give Stewart and Keith a follow. Aldav Law, ALDAVLAW on Instagram, on YouTube, all over the internet. Show them some love. Give me a follow at Just Plain Zack. Follow the podcast at No Filter with Zack. And I will talk to you guys on Monday, unless there's something breaking that happens over the weekend. You can keep up on Instagram. But until then, I will talk to you guys later. Bye.